Well, good morning, everyone. It looks like we still have some people joining the webinar. So thank you for all taking the time out of your schedule to join us on this webinar. My name is Jeffrey Sunikawa. I'm the Director of Research and Court Services at the Office of Court Administration. We are a state agency here in Austin, Texas that serves the Judicial Council and the Supreme Court of Texas. We often get to do webinars to educate clerks and judges and court staff on topics that might pertain to them, so we're excited to be here. But we really just want to say thank you for taking the time during these particular stressful times that we're facing during the COVID-19 crisis. I am delighted and excited to introduce a very knowledgeable panel of experts that are here to help me provide this presentation, provide you really useful information for today's webinar. First, I want to introduce Sherry Woodfin. Sherry's on your screen. Sherry previously was the district clerk for Tom Green County for over 20 years. So many of you probably know Sherry. Earlier this year, we were excited to be able to steal Sherry from Tom Green, and she is now working for OCA as our court consultant. Sherry's role is to provide assistance and resources and education for courts, judges, and clerks all around the state of Texas. So no job is too big nor too small for Sherry. Next, we have Kathy Horvath. Kathy is not on the screen, but she's on the air. Kathy is the Chief Deputy District Clerk for Teresa Keel over in Guadalupe County. And lastly, on your screen, we have Shrina Gilliland. Shrina, wave. Shrina joins us from Parker County, Texas, where she is the District Clerk there. These three ladies are incredibly knowledgeable. They've been doing this type of work for a while, and they have put together a fantastic presentation that I'm really hopeful will provide a lot of useful information and just anything that might be useful to you. I hope you get information from this webinar. So briefly, I want to go over today's presentation. All of the attendees for today's webinar are muted. We have close to 300 people registered for today's webinar, so as much as we would like to hear everyone and interact, it just might get a little difficult. So so everyone is muted. There is a function, as you'll see on your screen, for asking questions. Feel free at any point during the presentation to submit your questions. We will be leaving time at the very end of the webinar to try to address as many questions as possible, but that is your opportunity to ask questions that you need the answer to. For anything that we're not able to get to during the broadcast, we will address them afterwards. And our plan is to collect all the questions that were submitted and provide all the answers and provide them to all the attendees so we can share the information for everyone. You'll notice on your screen that there is a place for handouts. We've provided a copy of today's PowerPoint presentation. We've provided a copy of the 2020 NICS Mental Health Reporting Manual that's developed by OCA. So again, that was just updated this month. We've also provided a question and answer document. That will be a living document on our website as we get more and more questions that are NICS related. So something that you can refer back to if you have additional questions that might have already been asked. So those are there for your use. In terms of timing, we're planning on going for about an hour and 15 minutes. We might get to about an hour and a half, but again, no more than an hour and a half. So again, saving time for questions at the end. And I'm pleased to let you know that we've applied for and we've been approved for an hour and a half of continuing education credits for today's webinar. So if you need assistance with certifying that, let us know afterwards. I think that covers all of the logistics. So without further ado, I would like to turn it over to Sherry Woodfin.
Good morning, everyone. I am sad that I don't get to see everybody's face. That's what I wanted to do. So we need to have a huge Zoom meeting is what I'm thinking for clerks to all join in so we can all see each other. But we're excited today to bring this to you, as Jeffrey said. So we're going to start with basically just kind of organization of that. Jeffrey mentioned many of the things already, but if we hope that everyone was able to get in with the webinar login, and then also at the end we will take the questions and try and answer them as best we can. If we can't, we'll get back with you. We are only going to cover things that are related to actual reporting, not things that DPS provides in their information. So entering the actual orders in the web in the system for DPS, that's not going to be covered. So on the next slide, have you ever had any questions about whether you're properly reporting your court orders related to mental health? I know as county and district clerks and staff, the importance of properly reporting cases to NICS may be a huge undertaking and a burden if it would be fair to say no more would want to be on the front page of a newspaper saying that a shooting was attributed because a clerk did not properly report something. So I know that it's kind of a driver for clerks because we don't like bad press, and I certainly can relate. And because of the responsibility falling to the clerk, it's certainly important to regularly question your staff and regularly review your processes to make sure that it's all being done. So I hope that this webinar helps in providing that information. I know some staff members are on as well as clerks, and I think that's great. But this will also be there for history, where you can go back and refer to it as you get new staff members that are responsible for this. So what we're going to cover, what we'll talk about first is history and the functionality of the NICS reporting system, national and state statistics, and reporting, the actual reporting of what you need to put into the system, and then retention of those records and resources. So National Instant Criminal Background Check System is what NICS stands for. NICS determines if the prospective buyer, purchaser of a handgun or a rifle or explosives is eligible to actually buy those things. So that's the purpose of this. The National Instant Background Check System was mandated by the Brady Act of 1993 after James Brady, the press secretary of Ronald Reagan, was shot. And you can go to the next slide, and it provides a little bit of just the history of when all this came about. The Brady Act was a long time ago, and as far as 1981 was when it actually happened, but it didn't actually start until 98. So that was a good 10 years almost. So James Brady also, I found this interesting, died in 2014, and the coroner actually said that he died from his gunshot wound that he sustained 33 years prior to his death. So the shooter has remained in a mental hospital since the incident. So next slide, we're going to talk a little bit about NICS and how it works. It's a centralized computer system, and providing the information of prospective buyers and the eligibility for them to possess a firearm. And when a person is buying a firearm, the seller, the FFL, which is Federal Firearm Licensee, contracts with or contacts NICS electronically or by phone. And I found this interesting as well. The NICS is customarily available 17 hours a day, 7 days a week, including holidays, with the only day an exception being Christmas. So the prospective buyer fills out a firearm transaction record at the place where they're trying to purchase the handgun or rifle, whatever. And the form and application is then submitted to NICS, and then NICS staff performs that background check on the buyer. So continuing on a little bit of how it works, the background check then verifies whether the buyer has had any criminal cases reported against him or any mental illness reported against him. And that NICS background check provides checks off of 3 systems. So there's a National Crime Information Center, which is a database that contains everything from open warrants to a registered protective order. Then the Interstate Identification Index, which only 31 states participate in that, but it is something that NICS goes in and checks those records, as well as the NICS system. So when they do a background check, they're checking more than just what they have in their database. They're checking these other databases as well. So the next slide provides a little bit more about the background. Generally determined, it's when they do a background check, it's generally determined within a few minutes of receipt of that inquiry. And I thought that was actually a pretty good return rate. If there's no match, the dealer just proceeds and the firearm is transferred to the buyer. If additional information is needed, follow-up or request, they then contact the agency that they want to follow up with. And that's where clerks may come into the picture here. If NICS ever contacts you about something that you've reported, they need more information on it. They want to make sure that a person is eligible. And so it's very important that we have that information readily available. As on the next slide, it talks about NICS has 3 business days to determine if a gun transfer is prohibited. So again, that part of that 3 days is if they have to call a clerk, then they need our information very quickly. So as the clerk of the court, it's imperative that we respond immediately or as soon as possible, as the time you are making is part of that 3 business days. So next is NICS Improvement Amendment Act, and Shireen is going to take it from here.
All right. Good morning, everybody. We're going to talk a little bit about the NICS Improvement Act and how that came about, what it was designed to do and gaps to close, and then we're going to talk a little bit about some statistics. Unfortunately, when things happen in the national news, that sometimes draws attention to where there's some gaps in current legislation. That's what happened following the Virginia Tech shootings in 2007. You can go to the next slide. So as Sherry mentioned, we've had gun control acts since the late 60s, and moving forward, we had NICS come about in 1998. The NICS Improvement Amendments of 2007 helped close some of those gaps. So the shooter at Virginia Tech had previously been adjudicated as a danger to himself, but it wasn't reported to NICS. So when he went to purchase a firearm before the shooting, there were no prohibitions in the database, and thus he was able to buy a firearm. On the next slide, it's important for clerks to know that this is where your submissions become so important. Some of the other gaps that were closed in the Improvement Acts of 2007 were making it clear that mental health adjudications are reported, not just a diagnosis or not just an allegation. It also provided avenues for those who have had their rights to purchase a firearm flagged or prohibited. There's avenues for them to have those rights restored. And then also made clear some ways to correct errors if things were wrongly reported. And of course, with all legislation, there's grants, money to get improvements within reporting in certain states and counties, as well as withholding of grants if states aren't in compliance. Specifically to the Virginia Tech shooter, he was accused in 2005 of stalking, and at that time the judge declared him mentally ill and ordered him to attend treatment, but that was not reported. So that's how the 2007 amendments came about. Then following in 2009, when the Texas legislature met, they also made amendments to Chapter 411 of the Government Code and Chapter 574 of the Health and Safety Code. So the screen that you're looking at now shows the numbers of the active records in the NICS indices. And you can see listed number 2, the prohibited category of adjudications for mental health. Obviously, there's other reasons why someone may not be able to purchase a firearm or explosive, but today we're just focusing on the mental health adjudications, and we're not focusing on CJIS or other reasons that may cause someone to be prohibited from buying a firearm. So continuing, just kind of looking at some statistics here. From November 1998 through December 2018, NICS conducted over 304 million background checks. In 2018 alone, there were over 26 million background checks submitted to NICS. Of these, NICS processed over 8 million, and state users of NICS processed over 5 million firearm transactions and 12 million permit transactions. So you can see that there's a lot of activity, a lot of background checks happening through the NICS. Okay. The next slide shows us the reason why these background checks are being performed, either for firearm purchases or explosive purposes. As you look at this chart, you can see that explosives compared to firearms have remained relatively static. But beginning in 2011, you can see a huge increase in the number of background checks being performed for firearm purchases. That's over 1 million increase just since 2011. Excuse me. Yes. Excuse me. 7 million. Pardon me. So again, you can see why it is so important to make sure that we are reporting correctly and promptly, and then making sure that we follow up as quickly as possible if the agency contacts you for follow-up information. They only have 3 days to make their decision. So if you have a request coming into your office, it needs to be top priority. And just, by the way, there's no cost for copies to provide those agencies with copies from your cases. All right, the next slide shows us reasons for denials. So when a NICS background check matches a record of the prospective firearm transferee, the NICS section determines if there is a federal prohibition. If there's not any, that's not the end of the story. Next, the NICS employee looks to see if there are any applicable state laws that prohibit the firearm purchase. From its inception in 1998 through December of 18, NICS has denied over 1.5 million transactions. Of these, 99,000 were in 2018 alone. Historically, the largest percentage of denials are based on the finding that a transferee has a criminal record. But if you go down the list a little bit there, you can see that over 40,000 have been denied based on mental health adjudication. And that's still a pretty significant number nationwide. This next slide shows you the number of checks, and just compared to other states, and in Texas alone, close to 1.5 million. So yes, the information that you submit is very important. Another reporting requirement that clerks do that is so important are your monthly OCA reports. This is a summary of the 2019 state statistics, and you can see how the compilation of all of those reports adds up. This is so that the state and national authorities can have an idea of how many cases, how many people are affected by these mental health adjudications. And then last statistic here for you. As of December 31st of 2019, just over 6 months ago, across the state, we have over 309,000 active cases in NICS just based on mental health adjudications. So again, that's just to emphasize the importance of timely and proper reporting.
Okay. Hi, everybody. This is Kathy. And as Jeffrey mentioned, I work for Teresa Keel, the county clerk in Guadalupe County. And so I'm here today to talk about, among other things, the orders that are reported to NICS based on a mental health proceeding or an adult guardianship proceeding, because those are cases that are handled by the probate courts, which are county level courts in the county. And so with the reporting of NICS, you know, back in 2009, House Bill 3352, enacted by the Texas legislature, is what added those sections to the government code, 411.052 and 411.0521, and the section of the health and safety code that discusses the method for restoration of somebody who's been restricted because of a mental health adjudication. And so those laws were added to bring Texas courts into compliance with and to implement the federal NICS Improvement Act, Amendments Act of 2007. When that bill was passed and enacted, it also required all clerks across the state to go back and check all of their records that would be subject to the NICS reporting from September 1st of 1989 through August 31st of 2009, and to go back and enter those orders into the NICS system. So that meant clerks had to go back and find all of the relevant orders in their records and enter those, and then continue entering any new orders that are subject to the NICS reporting from that point forward. So we had a lot of work to do back when that bill was passed. We had until 2010, I believe it was, to get all that in there. So hopefully you've had a chance to do that. If not, no time like the present. You need to sit down and figure out a way to do that. So on the next slide, this is the website, on the DPS website, where you can get information about the Criminal Justice Information System reporting. And if you look on the lower left side of the screen, you see the NICS indices entry reporting, and that's where you would go to enter these records or get information. Actually, that's where the manuals and the instructive information are located for the NICS record entry. There you go. Thank you. So make a note of that website. You'll need to go there if you haven't already been. Okay, and on the next slide, so the county and district clerks have to report information on prohibiting mental health adjudications and commitments to the CJIS system within 30 days of that order being signed by the judge. And even if a clerk has no activity for a particular month, you still have to submit a zero activity report to be in compliance with the rules. So, and that also applies to any order that is subject to the NICS reporting. So if you get an adult guardianship order signed, you've got 30 days to get that turned into NICS. And it's not hard to do. And the instructions, as I say, are available on the DPS website, and they're available with your handouts too today. So Section 411.0521 does not specify a requirement for clerks to submit those zero reports, but that statute does charge the Texas Department of Public Safety to establish by rule the procedures for correcting and submitting records. So DPS wants to make sure that just because we didn't report something doesn't mean that we don't have something to report. And the way to create a record that ensures that all records have been reported is when you don't have something to report, you've got to submit those zero activity reports. So so that DPS knows, okay, well, the reason there's nothing here this month is because they didn't have anything. And they're not just wondering if maybe we forgot or, you know, or we're not in compliance with the rules. So you've got to get those zero activity reports in. And I know DPS, the CJIS fields reps are doing audits right now. They're getting in touch with clerks across the state to help everybody get that done. So if you have any questions about getting those turned in, you can check with your CJIS rep as well. And again, this slide kind of goes over the same thing. So a zero report has to be entered for each ORI under which a clerk reports. Each of the courts that you serve as a clerk is going to have its own ORI. And you may have more than one court issuing orders that would be subject to the NICS reporting requirement. For instance, you may have a court that is handling the mental health adjudications, but it's a different court that's doing the guardianships. So you've got to report under each court's ORI. It used to be reported by county, but that changed some time ago. So make sure that if you don't have any orders to report from any of your courts, that you enter those zero reports for each one of your courts. Okay, and that's explained, and you can see how to do that in the CJIS NICS user guide. her instructions. Okay, so what do you not report? Don't report guardianships of minors. Guardianships of minors are not typically created because of a mental incapacity. The reason they're incapacitated is because they're not of legal age, and they need somebody to act on their behalf. So for that reason, the guardianships of minors are not intended to be reported to the NICS system. Don't do it. A lot of clerks across the state handle emergency mental health detentions and warrants. When somebody in the community is reported to the court as being a danger to themselves or others and needs to be examined for possible mental illness, the court may order that person be picked up under an emergency mental health detention warrant. That order in and of itself is not reportable to NICS, okay, because it's not an adjudication of mental illness. And that also applies to an order of protective custody, because typically the patient is going to be held in protective custody for the purpose of examining them to find out if they're suffering from mental illness. So there's been no determination made yet. There's been no adjudication yet. So those preliminary orders are not reported to NICS. It isn't until you actually get an order for temporary mental health inpatient services on a patient that you would report that to NICS. Okay, and voluntary commitments are also not subject to the NICS reporting because you don't have an order. The person did it willingly themselves because they knew they needed help. Okay, do not report commitments for outpatient mental health services. I think it was the 2017 legislature added some sections to Chapter 574 Health and Safety Code that now authorizes the courts to order temporary or extended outpatient mental health services. And those orders are not subject to NICS reporting because they're not covered under the Government Code Chapter 411 statute. So don't report outpatient orders, only the inpatient mental health orders where the judge is actually committing them. Applications for court-ordered inpatient mental health services that are going to another county, and this happens in a lot of counties across the state that, for instance, here in my county, Guadalupe County, we don't have a facility where people can receive treatment, inpatient treatment for mental health or mental illness. And so what we do here, we're right next to Bexar County, San Antonio, so our judge may issue an order for protective custody, but then the patient typically will be transported over to San Antonio to the probate court over there for further proceedings after a determination is made on, whether or not they need mental health treatment. So our judges here don't actually issue orders for mental health treatment. They only issue the preliminary orders to bring that person into a place where they can be examined and then sent to San Antonio if it appears that they need to go through further proceedings in a probate court. So we don't report our mental health orders to NICS because they haven't reached that level of a mental illness adjudication. We also don't report court-ordered inpatient chemical dependency or alcohol services. Those are not covered under the Government Code statute. Okay, so if your judge does not sign a mental health commitment order, don't report the preliminary orders to CJIS. Okay. So what orders do you report? The orders issued on or after September 1st, 2009 must be entered into the NICS CJIS system not later than 30 days after the date of the court order. If an appeal is filed and the appellate court reverses that order that was previously entered, then the entry in NICS has to be canceled by the clerk within 30 days after receiving the reversal mandate from the appellate court. So you need to be watching for that and be aware that that's something you need to do in a timely manner if you get an appellate ruling that overturns the previous order. And another note I want to make too is that on these mental health orders and guardianship orders, and even the criminal court orders when they're ruled incompetent to stand trial, any of these orders, you don't have to wait until the first of the following month to submit these to NICS to sit down and put them all in at one time. In our office, we enter them as we get the orders. Because if you think about it, first of all, these records are entered individually into the NICS system. Okay, you sit down and you enter them one by one, the name of the patient, the date the order was signed, etc. So they're individual records. So there's not like a bulk upload or anything like that. And the second thing is if these people really are mentally ill or mentally incapacitated and should not have access to firearms, then the sooner you get that order reported, then the sooner the NICS system will have that person flagged so that they cannot obtain firearms under the law. So it just makes more sense to get it in there as soon as you can. That's how we do it in our county. As soon as we get an order from the judge, we punch it into NICS. Okay. The mental health orders that you need to report are those orders for temporary or extended inpatient mental health services. Again, not outpatient, just inpatient. And that includes individuals who are sent to state hospital. It doesn't matter what facility it is, state hospital, private hospital, Veterans Affairs hospital, whatever. If a court has ordered them to submit to inpatient mental health treatment, then no matter what facility they're at, that order has to be reported to NICS. And orders for a person who is determined to have intellectual disability for long-term placement in a residential care facility under Chapter 593 Health and Safety Code, those are also reported to NICS. And a quick note about that, an order for commitment in a long-term placement residential care facility under the Health and Safety Code Chapter 593 is very specific. It refers only to a state-supported living center operated by the Texas Health and Human Services Commission. There's 13 of those across the state, and it also applies to the ICF IDD component of the Rio Grande Center, another specific facility. You can get more information about those SSLCs and the Rio Grande Center on the HHS website, which is at hhs.texas.gov. Okay, so it's not just any facility that an intellectually incapacitated adult would be placed in by their family or whatever. This is very specific to certain facilities. So in breaking down the mental health commitment orders to report, the commitments for temporary extended inpatient mental health services, if you have more than one commitment order, you're going to report each one of those commitment orders. Okay, so, and if the court issues a temporary commitment order and then extends it later, each one of those orders has to be reported to NICS. They're all going to have different dates of the order, right? So, or if the court does another temporary commitment order, you're going to enter that one as well. So any initial commitment order and any subsequent orders that follow all need to be reported. And I think, yeah, the next slide is where we talk about how to file those mental health cases. A new case is actually required for each application for court-ordered inpatient mental health services, regardless if the application is temporary or extended mental health services. A lot of clerks do file the orders under the same case number. If you have one event and you're still working within that case number, you have that initial temporary mental health services, and then the judge does another temporary mental health order on that same person under that same event, then the case number would probably remain the same in most courts. I think it would in ours too. What you're going to have to do when you submit those subsequent orders in NICS under the same cause number that you previously reported under is you're going to have to add some kind of suffix to the end to distinguish it from the first order that you submitted. So if you've already put in that first temporary mental health order, but now you've got an extension of the temporary mental health services order, you put the cause number in and then add -1 or -2 or -3 at the end of the cause number to distinguish it from the first order. And then the relief from disabilities, a person who's discharged from court-ordered mental health services can petition the court for an order stating that they qualify for relief from the firearms disability. That's found in section 574.088 of the Health and Safety Code, and that's where the detailed information about the requirements for the proceeding are. So the only way you're going to cancel that NICS record for a person who has been who has submitted to court-ordered mental health services is they have to do this process where they file an application with the court that originally ordered the mental health services to prove up to the court and provide evidence that they are recovered and that they should be granted relief from disability under the NICS Act. And if they do get such an order, then when you go in to cancel the NICS record, it's going to have a field where you're going to have to answer either yes or no to, is this cancellation due to relief from disability orders? And so in this case, if they got that order, you would answer yes. Okay. All right, guardianship orders to report. Again, only adult guardianships, not guardianships of minors. There are different types of adult guardianships. You can have a guardianship of only the person. You can have a guardianship of only the estate. You can have a guardianship of both the person and estate. And then you can have temporary guardianships. So if any of those types of orders are signed in which the court has found that an adult is not capable of handling their own affairs, then you're going to submit that order to NICS. I had a question come up not long ago. Somebody had a temporary guardianship granted, and then a couple of months later, they had another hearing, and the court actually converted the temporary guardianship to a permanent guardianship. And so the question was, well, do I have to report that second order? And if you review the statutes, it doesn't strictly say, but I think it's safe to go by the directions that we have regarding the mental health orders. If subsequent orders are signed, then they should all be reported. And so the difference is when you're converting a temporary guardianship to a permanent, you're going to have a later order date, and that's going to show NICS, hey, this is still going on, and this person is still subject to these restrictions. And it's also going to require you to add like a -1 or a -2 at the end of the cause number, because, again, you're submitting a second report under the same case number. Okay? So, and also keep in mind that these orders have to be reported even if Texas Health and Human Services is appointed as the guardian. Again, if a temporary guardianship is created, because a temporary guardianship can't be created unless the court has adjudicated this adult to be incapacitated and incapable of managing their own affairs. So we've met that criteria, so it needs to be reported. And many times the court will find somebody to be partially incapacitated. But if that court order says that they are mentally incapacitated to any degree, we're supposed to report those orders to NICS. Now, so what happens when an adult who's under guardianship recovers and they get better? Maybe the reason they were under guardianship is because they were in, maybe an automobile accident or something, and so they're being treated for that. And then at some point they recover their capacity and they go back to being able to take care of their own business. That person can then petition the court to have their capacity judicially restored and to have the guardianship terminated. And if the court finds that the evidence supports that application, then the court can grant that and restore the person's capacity and close the guardianship. When the court does that, then the person can then go back to the court and apply for relief from disabilities under the NICS Act under Section 1202.201 of the Estates Code. It's a specific section that talks about what a person would have to do and the requirements that have to be met in order for their NICS record to be canceled. And again, if they get that order, if they come back to the court and the court says, yes, I agree, you're completely recovered, and we're going to sign an order to give you relief from this restriction on firearms. And so then when you get that order, again, when you put it into NICS to cancel the record, you're going to answer yes to the relief from disabilities question because the court has ordered relief from disability. Had another question from another clerk. If a successor guardian is appointed, do I report it? So you have an ongoing guardianship of an incapacitated adult, and they had a guardian, and now that guardian has either said they can't do it anymore, or maybe they've passed away, and another person has applied to be appointed guardian. That does not get reported to NICS because the status of the ward in the guardianship hasn't changed. They're still an incapacitated adult. They're still under guardianship. All this does is put somebody else as a successor guardian in place to continue to care for that person. Okay, it doesn't actually change the status of the guardianship. So you do not report an order appointing successor guardian to NICS. And again, don't report guardianships of minors. Cases in which an order previously reported, yeah, you can go ahead, Jeff, and click. There you go. If an order previously reported is reversed by an order of any court within 30 days after receipt of the mandate from the appellate court, you need to get in there and cancel that record. And a person whose guardianship was terminated because their capacity was restored, again, can file that application requesting relief from disability. The thing to keep in mind is that an order restoring capacity and terminating a guardianship does not automatically remove the person's disability to purchase a firearm. Okay, they're still going to need to file that additional application and get another order from the court that provides that relief from disability under the Act. Okay, so the first order just closes the guardianship and restores their capacity. So don't cancel that NICS record just on an order terminating a guardianship and restoring capacity. Okay. And I think that's it for guardianship, right?
All right, next up, we're going to talk about what you need to be reporting on your criminal cases. So this is something that your clerks handling your criminal files need to be aware of. They need to be authorized to be able to submit to CJIS and to NICS. So what do they need to be looking for? They need to report cases in which the defendant was acquitted by reason of insanity or lack of mental responsibility, regardless of any type of inpatient treatment, residential inpatient treatment, etc. Then you also need to report orders finding the defendant incompetent to stand trial. So on both of these types of situations, you will have an order signed by the court declaring them either they've been acquitted or they're incompetent to stand trial. You're not going to report it just based upon motions or suggestions or defenses that are raised with respect to they should be acquitted or be found incompetent. You're actually going to have a signed order declaring that from your judge. Next slide. All right. In a case where the defendant is found by the court to remain incompetent in order to continue to be committed, finding that they remain incompetent is not reported. Only the original incompetency is reported. However, if there's an order continuing the defendant's commitment, that is reported. Sometimes that's called a criminal commitment. As Kathy was talking about earlier, some clerks give it a separate cause number. You don't have to. If you do not give it a separate cause number, when you go to report it in CJIS and NICS, you need to make sure that you're adding a suffix. So example, your cause number -1, -2, etc., with respect to those continuing commitment orders. And side note here, you might be getting reports from doctors saying that the doctor believes the defendant is incompetent. You don't report yet. You wait until you have that signed order from the judge. So if you see those reports coming in from the doctor, that is not something to trigger reporting yet. And this kind of goes into the next slide a little bit. If they are later found to be competent to stand trial, that NICS entry stays. The person has to follow the same processes similar to what Kathy was talking about to have their rights restored. So if an individual has had his or her rights restored and they have to file a petition and go through court, have a hearing, and there's an order saying that their rights are restored, then the entry in NICS can be canceled. So the best way to go through that process is under the CJIS NICS user guide and canceling NICS transactions. At the end, there's a response required to relief from disabilities. Because that individual's rights are restored, you have an order restoring the rights, you're going to select yes. Okay, so the next slide talks about, oops, we made an error, we recorded something improperly. So if a record was entered into the database in errors, for example, if you reported just based on the doctor's report saying incompetent and you didn't have an order yet, then that entry needs to be canceled. So in this instance, the question relief from disabilities, you're going to enter no because it's being deleted due to an error rather than a formal order relieving that person of their disabilities. So bottom line, once it's reported, you're going to need a signed order restoring disabilities, or if it's reported and you realize there's a mistake, then you can go in and correct that mistake. And then Kathy's going to talk a little bit more in detail about petitions and to restore rights.
Thank you, Sharina. Okay, to regain their rights to possess a firearm, a person has to petition the court. This is what we're talking about, and it has to be the court that originally had jurisdiction over the previous case, their mental health case, their guardianship case, or the criminal case in which they were found incompetent to stand trial or acquitted for reasons of insanity. And they go back to the court and file an application for restoration of their rights. Specifically, under the Health and Safety Code, mental health commitments, the process for applying for relief from disabilities is under 574.088, and in the Estates Code for an adult guardianship, it's under 1202.201 of the Estates Code for a person who's been previously under an adult guardianship to petition for relief from disabilities. The acquittal and incompetency to stand trial, I don't see a provision in Texas law for restoration or relief from disability for those folks. So, I look to the United States Code Section 925, and it says that an application for relief from disabilities is filed with the USAG, but there's probably other information they need to gather. But basically, people are not going to be automatically removed from NICS just based on something expiring or an order no longer being applicable, such as a guardianship order. They have to specifically obtain from a court the right to regain their rights to possess a firearm. So the data that you have to report in NICS, all of the records have to contain this list of information. The court ORI, again, each court has a unique ORI number that identifies that court. And then you have to have the case number and the case type, the date of the order or judgment, and the person's name and date of birth. If you only have partial, you can enter only 2 of the 3 numbers in the birth date. You have to have their sex and their race. If you don't know their race, you can select unknown, which is frequently the case in a lot of these cases. We don't have that information. The clerks should try and capture all of the required data elements for the cases. Changes to processes, forms, and case management systems may be needed to capture that information so that you have what you need when you sit down to enter that record into the NICS system within the 30-day time frame. Okay, so you might need their date of birth from their arrest record, etc., or jailing record. The next slide shows you the fields that are optional. In other words, you can save the record without entering this information. But if you have this information, you absolutely should enter it. It helps to identify the correct individual, and that way, when a person is applying to purchase a firearm, it will be the NICS will be able to specifically identify, yes, this is that person, and they're restricted, or we don't have any restrictions on them. So always try and obtain this information to help clearly identify the person who's subject to the restrictions. Not always easy to do. In the criminal cases, a lot of times their arrest records are going to have this kind of demographic data, their driver's license number, maybe their social security number. Anybody who's arrested is going to have a state identification number, what we refer to as a SID, and there's a field in the NICS system for that as well. That really helps to identify who that person is. And it avoids confusion if they have a common name or something like that. And so try and get that information if you can. On the other case types, on the mental health case types and the guardianship case types, the information that's required to be submitted for those applications doesn't necessarily provide all of this information that you need for the NICS report. So a lot of courts are using the data collection forms in order to get that information from the parties. In the July 2020 Texas NICS Mental Health Reporting Manual that was just recently updated by the Office of Court Administration, and you have it as a handout here with this webinar, it actually includes towards the back, there's 2 forms that originated in the probate courts here in the state, in Judge Herman's court in Travis County. There is a form to collect this particular information on a mental health case, so that you can get the patient's social security number, their driver's license number if they have one, if they've ever been arrested, that state ID number, which is really helpful because that's tied to their fingerprints. And then there's also a form there for adult guardianship so that you can collect that information on them too. Again, a person who's under adult guardianship, they may not have that criminal history record of a jailing, but so the form will help you to gather that information about the ward, their specific identifiers, so that you have that information to enter into the NICS system. because the more information you have, the better the system's going to work, and that's what we all want. We have to report older cases to NICS. Again, back in 2009, when House Bill 3352 was passed, clerks were required to go back and submit records going back to September 1st of 1989 up to the present, and we were supposed to get them all in there by September 1st of 2010. So hopefully your office was able to accomplish that. But even though the deadline's passed, they still got to go in there. So if you haven't previously gone back and audited your records, you need to try and figure out a way to do that. You might be able to use your case management system to query certain data to narrow it down, because obviously you know going through every single case file would be cumbersome. So try and come up with ideas. You know how you've been entering your data all these years. What events can you use to try and query those cases to figure out which ones may have orders in them that would be subject to this reporting? So even though the deadline is passed, you still got to put those cases in, and a diligent review of all your records is going to be required to make sure that all the relevant orders are reported. And again, as I think it was Sharina that pointed out earlier, we don't want to be the clerk that didn't submit an order that then allowed somebody to purchase a firearm and then harm others. We don't want to be that clerk, okay? So figure out a way to get it done. It's to everybody's benefit. Again, suggestions for researching older cases, running reports from your case management system, reviewing the docket books. You just need to review the actual case files, and you've got to look at those orders. Do those orders contain the adjudication of mental illness or mental incapacity that you need in order to submit that record to the NICS system? For instance, in criminal cases, you can search for acquittal and dismissal dispositions. And obviously, you're going to have a lot of dismissal dispositions, but you know, we may have put in a report or something like that as an event that'll help us to query those cases. Okay, so the next slide is going to show you the website address where you can get to the updated July 2020 NICS Mental Health Reporting Manual from the Office of Court Administration. And then you also have the DPS NICS Indices Entry User Guide, which is extremely helpful. If you've never sat down and entered a record into the NICS system, that's going to help you a bunch. It tells you how to get registered for it, get logged on, and use the system. So be sure and use those tools. Okay.
So we're going to talk a little bit about record retention. This should not take very long because there are no specific retention requirements for NICS reporting. They fall under all these other case categories that you have retention requirements for and retention plans for. So if it is related to a criminal case, then you would keep it like you keep your criminal records. And so on your guardianship commitments and admission to state care. I would note that it is suggested that the reports themselves that you submit, that you keep those as a permanent record. You can certainly keep them in electronic format, but keep them as a permanent record. So if you're ever asked to refer back to when maybe something was reported, if it was reported in error, whatever, then you have that record that you can go back and look at. So it's recommended. It's certainly not required, but recommended that you keep the actual reports that you're putting in NICS permanently. The next slide provides a little bit of a best practice. So understanding that many clerks may now have electronic methods for managing records and can easily locate records on an individual using an index. Still having to maintain that record in a paper format, this would maybe apply to you. It's recommended that you keep anything that is reported to NICS in a maybe in one big file drawer or something, so you can access it quickly. That is to help if FBI has any additional questions that they want to ask, and you need to be able to locate that record quickly. So that's a best practice recommendation. There's another best practice recommendation that provides if you maintain personal identifying information obtained from other database or sources. For instance, a lot of, I know working in a clerk's office, a lot of things may be in your CMS that is not necessarily from a document that's in your possession. Maybe it came from law enforcement, maybe it came from something else. So if you enter something, for instance, a social security number, it's not in any place in your file, but you've got the social security number from law enforcement, then make note of that, because maybe that social security number is wrong in law enforcement and you've entered it. So there may be questions about that. So you can say, yep, I got that from law enforcement, and here's where and how I did that. So keeping a record of that is a good idea as well. So last, we have some resources here. We've talked a little bit already about some of these, but we just as a overview, you have the NICS mental health reporting manual that's been recently updated. You also have DPS manual online here. And then last is for NICS reporting questions as to the actual use of the system. Certainly can call your CJIS field rep, and it's highly recommended that you do that if there's any issues or any questions about previous reports and how and when you need to get those done. There's a general email that will help you get to that unit, and also a phone number provided. So we're going to go into questions, and as Jeffrey said in the beginning, there's almost 300 people on the call, and so there's no way that we can hear your voices, even though we would love to. But we want to be able to take your questions if you have any. I'm looking here on our list, and I don't really see anything that's not already been answered, because there are a few little things here and there. But if there's any questions that you have, if you'll enter it in the questions line, we will try and answer those questions as best we can. And if we don't get to all of them, we're going to update that frequently asked questions and answers list that we've provided as a handout, and get that out to everyone. So anybody have any questions? If technology is working properly, which we'd like to think that it is, I don't see any. Am I missing them, Jeffrey?
Sure, I'm seeing quite a few questions, so I can go ahead and review.
Yeah, if you would. It's not showing up on mine. I'm sorry.
Okay. So one of our viewers is asking, what agencies should not be charged for the NICS documents?
Typically, you're going to be getting requests from the FBI. You would not charge them for copies. Just in our office, as a practice, any state or federal agency that is seeking copies for their purposes, whether it's related to NICS or not, if it's some sort of investigation or follow-up, even if it's for hiring purposes, we don't charge them, just as a courtesy to other governmental agencies. But on the NICS side of things, you're going to probably be seeing it coming from the FBI.
Okay. On the guardianship side, someone asked, do we still send cancellations when the incapacitated adult dies?
That is not specified by the statute. We don't do that. You know, I mean, you could check with your CJIS rep and see what they recommend. I've never had our CJIS rep tell us that we needed to cancel a record for somebody who has died, because presumably the federal government is putting 2 and 2 together when they get, you know, the Social Security death index. But the statute doesn't instruct the county clerk to report the death of the ward under guardianship. It's not an authorized reason to cancel the NICS record, as far as I know. But check with your CJIS rep, see what they say.
So Kathy, also on guardianship, someone asked, in the order on guardianship, does it have to state to possess or use of a firearm?
No, it has to say that they are incapacitated, either partially or fully incapacitated.
Okay. Let's see. Another question on guardianship. If you have a guardianship for an individual that has died, do we need to remove it from NICS?
No, I think we just answered that. The statute doesn't require it, but they can check with their CJIS rep and see what they recommend.
Kathy, another one for you. Someone asked, did you say that you all enter your orders on guardianships as soon as you get them and not just at the beginning of the month?
Correct. Now, I'm not Harris County, so I'm not getting, 300 guardianship orders a month. We probably get maybe 3 or 4 a month. So just as we get those orders from the court, we go ahead and open up NICS and we go in there and we enter that record. Because, I mean, if you think about it, any order that you get that would make a person subject to the firearms restrictions, NICS needs to know about it as quickly as possible. Because you don't want that person, deciding to go down and purchase a weapon, particularly on the mental health docket. If somebody has been, ordered to receive mental health treatment, of course, if they're inpatient, they wouldn't be out on the streets. But just the same, if you think about it, when you get an order that restricts somebody's access to firearms, NICS needs to know about it right away. I would not wait till the end of the month. You've got 30 days to report it. That's your deadline. But the sooner the better.
If I can tag on to what Kathy said, we also, on the criminal cases, we report same day that we get the order. Typically, we're reporting CJIS when we get the judgments, and if there's anything NICS related, as soon as that order comes in, we're doing the same thing. We report it same day. As we move into more electronic environments, and I know that all looks different in every county, you may not always have an order sitting on your desk to remind you to go back and enter it. And so, especially if you're paperless, when you're on that case, you need to make sure that you're completing everything, because essentially once you hit save and move on to the next case, if there's no paper, there's really not a reminder right in front of you to do something. And then I also think you need to make sure that you have internal quality control practices that make sense for your office. So once a month, we run reports based on certain events and go in and check those cases. And then we also follow up and make sure it really did make it to CJIS and really did, or excuse me, NICS, and really did. It really
correct, and that's a good point. That's a good point, Sharina, is that users can go into NICS and they can search for a record. They can only look at the records that were submitted by their court's ORI, under their court's ORIs. You can't look at orders that were submitted for your neighboring counties, for instance. But you can go in and verify that your records are in there. And obviously pull them up and add additional information. There's a way to supplement if you don't get their social security number till later, and then, now here it is. You can go in and update that NICS record. There's a method for doing that, and you'll find the instructions for that in the manual. But yeah, you can do a search for a record, and we do the same thing, Sharina. We run an event report at the end of the month, and I go in just to make sure that all the relevant orders were submitted.
Another thing to add a little bit about that is Governor Abbott in September 2019 signed an executive order requiring information to be entered in CJIS within 7 days. And then that's going to change in 2020 to 5 days. So even though NICS is a little bit different than CJIS, I would suspicion that there may be was a little bit of a misunderstanding or not completely comprehending they were two separate things. So you have to do your CJIS stuff now within 7 days versus 30 days because of that executive order. So just keep that in mind. So it might be something that, it will change by executive order or in the session to make it required. So if we already do it, then you're ahead of the game.
Right. Because honestly, 30 days seems like a long time to wait before entering a relevant order.
I agree.
Yes.
So Sherry, there's a few questions about what was entered in the past. So I'll read a few of these and maybe you can summarize it. So someone asked, so are we responsible to go back and research and report on old cases before we took office? There was a question, is there a way to quickly see what was entered by clerks in the years past prior to our office's administration to ensure that they were reported accurately? And then how can we check to see if a previous clerk reported previous orders? So I think they're all asking the same question.
So what we had hoped to basically provide, I was not able to get from DPS. So what I would encourage you to do is get a hold of your CJIS rep, and they can pull your history and provide you any month that doesn't have a zero report or a case reported. And then you should be able to tell by that report whether or not there are any holes in your reporting, and go back and fill those gaps. If you if you've just taken office and you have no clue whether that clerk before you went back into the historical requirement back in from 98 up through 2010, there is definitely a big push to make sure that that is done. And it was supposed to have been done by 2010, but they encourage you to still do that. There's no penalty. So you're not going to get in trouble because it wasn't done. So just figure out a way to make that happen within your county. Right now might be a good time because of the kind of standstill with COVID, and maybe it might provide opportunity for people to take things home and look through case files that might fall into these reportable orders that need to be done. So just contact your CJS rep. That's all we can tell you about the history, and they should be, and I've been told that they will provide what you need in order to know what needs to be done.
We have a couple questions on mental health reporting. I'll read these two. I think they're related. Individual says that they're confused on what mental health cases have to be reported, that they've always reported every mental health case that's filed by the DA's office. And someone else says that all of their mental healths are filed, all their mentals are filed as orders on protective custody or temporary, and why are these not reported to NICS? They said that also all of our applications for court-ordered mental health are proposed patient, and we see that these are not reportable. So can someone elaborate on that?
Yes. Okay. So the difference is between an order, for instance, an order of protective custody and an order for inpatient commitment for mental health services. The order for protective custody is a very temporary order. It only will allow the authorities to detain somebody for 72 hours for the specific purpose of determining whether or not they're mentally ill. Okay? So that order for protective custody doesn't say this person is mentally ill, but it does say that the court sees evidence that they might be and could be a danger to themselves or others, and therefore the court's going to order that they're held in protective custody for further medical and psychological examination. Okay? So you haven't crossed that threshold of the court having all the evidence it needs before it to say, okay, you are a mentally ill person, and you're not able to make these decisions for yourself to subject to treatment. So the court's going to order it for you because you pose a danger to yourself or others because of your illness. Okay? And if you just think of it in those logical terms of, you know, did your judge order somebody into an inpatient commitment for mental health services, whether temporary or extended? Did the court make a finding and adjudicate, yes, this person is mentally ill? And that's the difference. That's the trigger. Okay? You're not going to report to NICS when you get an application for mental health services because it doesn't always result in an order. You have to have an order from a judge that says, I find this person is mentally ill.
Kathy, someone asked, when you receive a transfer in a guardianship case from another county, do you need to also?
Yeah, this is a $64,000 question. I have asked Cassandra Ritchie at DPS about this. And, you know, DPS is always going to err on the side of caution and say, you know, if you're not sure if it's been reported, yes, report it. Technically speaking, the clerk who is receiving an active guardianship, in a guardianship that was previously granted by another court in another jurisdiction, okay? So when it comes to you as the new clerk, you don't actually have a new order declaring somebody to be mentally incapacitated and ordering that another person be appointed their guardian. You're just taking in the one that was signed by the previous court. Now that previous court's order should have already been reported to NICS, okay? So technically speaking, you have nothing upon which to base submitting a new NICS report because you don't have a new order finding incapacity and appointing a guardian. But it's tricky because what you want to make sure of is that somebody does it, okay? And you have no way of knowing whether or not the clerk of the previous court submitted that NICS report because you can't search the NICS system for reports submitted by other clerks, okay? So what I'm thinking would be the best thing to do is when you know you're going to be receiving a transfer from another county, and oftentimes that transferring clerk will contact the receiving clerk to say, hey, we want to e-file this to you. Can we do it that way? Because that way we don't have to send you a big old box of paper. So when that communication between the clerks is initiated, that's a great time to ask them to please also send something verifying whether or not they submitted that NICS record when the guardianship was granted. If they can't do that, they should still sit down and punch it in because it was their judge that issued that order. But if for some reason they can't, or they're not going to, or you just can't get a straight answer on it, then I would err on the side of caution and go ahead and submit it. Okay, and the date of the order is going to be back whatever date that other judge originally signed the order. And that's going to be challenging because his ORI is not the same as your court's ORI. So you may, when you get a situation like that where the previous clerk, cannot confirm that it was submitted, or won't provide the information, then you might want to contact your CJIS rep and find out what they recommend is the best way to handle that. Some way or another, somebody needs to make sure that that record is in NICS.
So, Kathy, guardianship is a popular category for questions. Someone says,
because it's confusing. Yeah.
Yes, I agree. Someone says, I don't understand why a permanent guardianship would be reported after a temporary guardianship has been reported. The status of the ward has not changed, just like when a successor has been reported.
Yes, it has. The order appointing temporary guardian can only last for, I think it's 180 days. I don't have the statute in front of me. But they're temporary, they're short term. Okay. Now in the NICS system, do we say temporary guardianship versus permanent guardianship? No, the NICS system does not allow us to distinguish between those two types of guardianships. So it's a legitimate question and a legitimate, concern as to, what's going to change. But if you think about it, when somebody, for instance, is subject to mental health commitment orders and they're found to be mentally ill and there's a commitment order, and then the court continues to issue subsequent orders because this person continues to be treated and subject to treatment for mental illness. Each one of those orders has to be reported, right? We kind of went over that with the mental health reporting. So I think in the guardianship in the same terms, yes, you're still going to have the same person's name, the same court, the cause number. You're going to have to add a -2 or a -3 or whatever after the end of the order to indicate this is a new order under the same cause number. And then that order is going to have a different date. And if you think about it, in and of itself, that's going to indicate to NICS that, okay, you know what, we had an order reported for this guy back in June of 2009, and now we have the second order reported for him in January of 2010. So that means that on that later date, he was still declared by a court to be mentally incapacitated. And most orders converting a temporary guardianship to a permanent, that new order is typically going to say the court finds that this person is mentally incapacitated and unable to care for themselves or take care of their own concerns, and so the court is going to order that the person previously appointed temporary guardian is now going to be appointed the permanent guardian of this person. So it's a continuation, and I think it's important information.
So there was a suggestion back when we were talking about looking at cases that were filed or not filed. Someone said, just as a suggestion, I've compared my open guardianship report to my NICS record search report, and that it was helpful looking back before they were in office. So just that's a little tip.
That brings up another point too, is that, and this is something that DPS has told us, the people at CJIS, Cassandra Ritchie, if you are going back through your old case files because you're not sure the previous clerk did it or whatever, and you're going to go back and you find adult guardianships that you figure out were not reported to NICS, but they've since been closed, you still have to go in and report that original order appointing guardian on the date it was signed by the court. And then because remember, when a guardianship is terminated, say the ward died and so the guardianship was closed. That's not a reportable order to NICS. The only subsequent guardianship order that would close the NICS report that you should submit to NICS is going to be an order of a person who has had their capacity restored and has filed an application for relief from disability. Okay? It might seem pointless to you to submit an order to NICS appointing guardian for somebody who has already passed away, but they want those records.
Sure.
And this is what I've been told, that we have to enter them.
So one thing in trying to determine exactly what DPS is wanting in trying to determine zero reports for clerks, it was mentioned that, which was surprising to me, like combination clerks have county court at law or county courts and have district courts. So if they have 0 cases in county court and 0 cases in district court, is 1 0 report good enough? And I was told that no, they should have a 0 report for each court, which we talked about the ORI. So I think that's certainly some information that clerks may not be aware of, that just 1 0 report for your county is not adequate. They want a 0 report for every court that you report for if you have no cases.
Right.
So I assume that answers the questions. Individual says they were told as a county and district clerk to only report 0 activity under 1 ORI and not both.
Wrong.
And that is incorrect now. They want them under both.
Okay. Let's see. There was another question. So maybe Sharina, you can take this one. So someone says, so as far as the county clerk, we report the federal firearms within the day of receiving the order that comes directly from the judges, but we don't receive orders right away. It can be up to a week later by the time we receive it. What should we do in that situation?
I think just as soon as you get it, report it.
Right.
It's not your fault if it's sitting in transit between offices. That just go ahead and report it as soon as you get it. Depending on your relationship with your courts, you might be able to have a friendly conversation and a soft nudge to say, hey, these types of orders really light a fire in our office. Can you get them down to us so we can make sure they're entered into NICS ASAP and not have any kind of delays? Because it could just be something, sometimes people, if they're not required to report these kinds of things, don't always appreciate the seriousness or the time sensitivity of it.
So a couple questions around protective orders. Someone asked, do we report protective orders as well if they are ordered to not have firearms?
I'm assuming you mean in the family context or something like that.
Yeah.
That's not necessarily in the NICS reporting.
Okay. And so someone says, what about a protective order issued in a family law case in which the individual against whom the protective order is issued is ordered to surrender any firearms in their possession to a law enforcement agency? Is this reported to NICS?
It's not reported to NICS. It's reported in a different area.
And that's the thing that clerks may not be aware of, is that the criminal CJIS reporting that we do and the other CJIS reporting that we do, evidently in the family courts as well, which I don't work with, but it sounds like your protective orders and that would be submitted the same way, are submitted through the CJIS system, and that in turn feeds data into the NICS system as it applies.
Really, from the clerk's perspective in dealing with NICS, we're really coming at that system from a mental health standpoint.
Right.
There may be other things that we're having to report in CJIS, and there may be a little bit of overlap on some of those issues. But if you think about NICS as more of your mental health reporting, at least as far as the county or district clerk is concerned, that may help a little bit, but it doesn't alleviate the traditional criminal history reporting that goes into CJIS.
Right.
A couple of questions around competency, and I'm sorry I'm jumping around on topics. There have been a lot of amazing questions submitted, and I'm just trying to join some of them together. Someone asked, if the clerk receives a motion to dismiss citing the defendant is incompetent to stand trial, is this reportable by the clerk?
Yes,
After you get your order signed.
right. If the court has issued an order making a finding that a person is incompetent to stand trial, then that is reported to NICS.
Someone says, I think I'm understanding you to say that during the pendency of a felony case, if the judge orders the defendant into a mental facility for a period of time, that needs to be reported, even though after that stay in the mental facility, the judge finds them to be competent to stand trial. Are they understanding that correctly?
I would say yes.
Yeah, I would say yes, if they're receiving treatment because they are incompetent, yes. And then if they are found at a later time to be competent and your case moves forward, you do not remove that from NICS until you have an order reestablishing their rights and removing that disability.
What about a motion to dismiss an order due to pursuant to CCP 46B.010? They are asking, would I submit this to NICS? I'm not familiar with that code. Well, we'll wait for someone to see if they can look that up. Back on Zero Reports, Sherry, someone says, I have 2 district courts and have been reporting 0 reports for both courts. Do I need to go back and report or can I start this month?
I would ask your CJIS rep, but I believe they want 0 reports for each ORI. That just gives them a good overview and snapshot that everything has been cared for as they're wanting it to be.
And a question, is the 0 report for each ORI, is that also for criminal?
If it's a different court number, yes. So if you have several district courts and they each have jurisdiction over criminal cases that may result in a incompetency hearing and order, then you would need to do 0 reports for each district court.
Okay.
What was the subsection on 46B?
46B.010.
Okay, what was the question in relation to that?
A motion to dismiss an order due to pursuant to that, would they need to submit that to NICS?
You know, it's not the dismissal that they're reporting, and that's what they need to keep in mind. Yes, you know, if a person is found incompetent to stand trial with regards to a misdemeanor prosecution proceeding, then it's mandatory that the court dismiss those charges. But the important part of that order is found incompetent to stand trial, not the dismissal. Okay, so if the order dismissing based on this says that, you know, the court finds this person is incompetent to stand trial and therefore is going to dismiss this proceeding, then yes, that's an order you're going to report.
Thank you.
Okay, but you could see it in 2 parts. You could see somebody come and say, okay, we've got an order to, you know, determining incompetency. Okay, now here's another order for dismissal. So that's why I'm trying to make the distinction. So.
Kathy, are you familiar with the DL 117 on guardianship cases?
Yes.
There's a question, do we submit those?
That actually has nothing to do with the actual NICS reporting. That is if a guardian is appointed for an incapacitated adult and the order appointing guardian specifically says this person cannot operate a motor vehicle. Okay, and so that form is then sent to the Department of Public Safety to let them know, hey, the court has determined that this person cannot drive a car or a vehicle. So that if that person does have a valid driver's license, then DPS knows to cancel that driver's license. So that's really not the mental health reporting for NICS. It's it has to do with driving. So it's a separate thing.
Let's see. Sherry, do you think, is there a problem with keeping the NICS document showing they reported it in the actual individual's criminal file as opposed to a big file of those types of records?
I think that's probably just a process call within their own department and how they feel like it would best serve their needs. But I wouldn't see any problem with it as long as that's their process.
There's still several questions about checking to see if older cases have been reported or if they're missing months. So I think we've given some tips and some suggestions on that. We have a couple of contact information on the screen. Obviously, Cassandra Ritchie at DPS is good for those questions. There's a general email address for court services at OCA. If you have Sherry Woodfin's contact information, Sherry is also an amazing contact to help you figure out ways to go through and see if you've missed reporting in certain areas or if there's any back work that you need to do. So certainly reach out to Sherry or the court services email address if we can help with that. I want to get just one or two more questions and then we'll be at time. That the questions just keep coming in. So we'll get these last couple of questions and then we'll try to wrap it up. Question regarding mental health, discharge versus dismissal and the verbiage we received from our DA's office. How do we report that? Was the case dismissed or discharged from her facility?
I don't think
Okay,
if you're talking on a criminal case.
Sounds like it. They said mental health, so.
Okay, I'm sorry.
I'm kind of confused. So we're talking about an order of dismissal. Read the question again, Jeffrey.
Question regarding discharge versus dismissal and the verbiage we received from our DA's office. How do we report? Was the case dismissed or discharged from a facility?
It sounds like a question about criminal disposition reporting.
I guess I'll answer with an asterisk that may not be fully understanding your question. Regardless of the outcome of your criminal case, unless they're acquitted by reason of insanity or mental capacity. But if you're talking about whether the DA's office dismissed or otherwise, whatever the disposition of the case, the key thing to report is that you have that order of incompetency.
Back on whether or not they can include these reports in the file. Someone says in the criminal case, shouldn't it be sealed or at least not public?
Yes, correct.
Yes.
You know, and the questions regarding going back and picking up old cases, like Sherry said, it's not required if you've recently come into office, but I think it's the right thing to do. And if you're struggling, one avenue might be to go talk to your DA's office or your CA's office of who might have handled those types of cases, because maybe they can run some reports or maybe they remember. If you're in a county that doesn't have very many, then it may be very easy to say, oh, I remember we've only had 2 guys in the last 5 years or something. But I think it's important to brainstorm and come up with ways to make sure that all of those cases really were reported.
All right, we are coming up on the hour and a half. This has been a really productive presentation. There are a lot of questions, it sounds like, and a lot of clarifications. So we will be compiling all the questions that were answered or not answered, and all the applicable answers, and putting those together and sharing them with everyone that is registered for this webinar, and also the greater clerk community, so that you can share with some of your staff. We really appreciate everyone taking your time. I have gotten a lot of questions about being able to access a copy of this webinar, as well as the NICS reporting manual, and those types of things. we'll provide a link to a copy of this webinar, as well as a copy of the PowerPoint at the conclusion of this. The NICS reporting manual is on our website. I will also include a link to the presentation and the video on our website as well. So we'll make sure that you receive it directly and indirectly so that you can reference it in the future, as also so you can share it in the future. Again, the content information for Cassandra at DPS and court services is up on your screen. I want to thank Kathy and Sherry and Sharina. They put together a wonderful presentation. They've shared a lot of valuable information, and I know they'd be happy to entertain any other questions that you might have after this or in the future. So thanks to the three of you for an amazing presentation.
Thank you.
Jeffrey.
Thank you, everybody.
Thanks for having us.
So thanks for joining us. Have a great day, everyone. We appreciate it.
Stay well, everyone.
Bye.